This is the Mediate Now with Winter Wheeler. Your clear choice for expert mediation and negotiation advice. But it's so much more than that. Take our advice, you will improve your entire life. Are you ready? Let's get to it. Today, I am welcoming the incomparable Shari Belitz to the podcast. Hi, Shari.
Hey, Winter, that's quite an introduction. I hope I can live up to it.
Oh, you definitely will. So Shari is a litigation consultant. She's the owner and CEO of Shari Belitz Communications, a litigation consulting company which teaches lawyers how to use social psychology to achieve favorable litigation outcomes. So of course I had to have her on the show, right? All right. So Shari is an attorney with over 20 years of experience in the legal profession. And prior to her litigation consulting career, she was an accomplished insurance coverage attorney at a law firm and litigation manager in-house at an insurance company where she handled complex mass tort suits for Fortune 500 insured clients. During her legal career, Shari studied forensic psychology, including advanced jury science and research at the graduate level. Shari has spoken at various legal and insurance industry conferences, as well as universities and law schools, about applying psychology to litigation, juror decision-making, and nuclear verdicts. I know we're all worried about that. Shari earned her Bachelor of Arts in Psychology, cum laude, from Syracuse University, a Juris Doctor, cum laude, from the New York Law School, and studied toward a Master of Arts degree in forensic psychology from John Jay College of Criminal Justice, which I did not know about you until today. And I think maybe like one of the coolest things ever, because I am like so obsessed with true crime and forensic files. And I tell you, like, I go to bed every day, like, to forensic files.
Okay, so Winter, I'm not trying to give you forensic FOMO or anything like that, but it was the coolest course of study. I had a hostage negotiator in my class. I had an FBI profiler in my class. I mean, this is a far cry from law school where it was like a poli-sci major on one side and a history major on the other side. Like, this was cool. I learned how to give the Rorschach exam, all sorts of personality tests. I studied psychopaths for a semester. So it wasn't even all just jury research and jury science, even though that was my laser point focus. It was cool. I'm not gonna lie.
Well, I mean, I've definitely got FOMO. So
As you
forensic
should.
FOMO. That's
As you
a
should.
new phrase, forensic FOMO.
Love it.
So Shari, as a trial consultant, you know, you would think that mediation would not be on your like top hit list. Why is it?
It's number one on my top hit list. I have to
Yeah.
tell you. Okay, I am team mediation, and that's not just because I'm team Winter Wheeler. I am team mediation, and I have been actually pre-COVID as well. Now, post-COVID, we have some serious issues with civil trials. I do think it is the only ethical, moral, safe way to go rather than to do virtual trials or do in-person pandemic trials, because you have severe selection bias problems. You have a lot of problems that are ultimately going to be appealable. However, I was pro mediation and team mediation even pre-COVID, because what a lot of people don't realize, and this was kind of my mantra when I was speaking with clients or prospects, is that trial consulting it's a misnomer. Trial consulting and jury consulting is a misnomer, which is why I prefer litigation consulting, because you don't want to bring in a litigation consultant right before trial. It's done. Of course, it's done for voir dire or mock trial at the last second. You want to bring in a litigation consultant early to do whether it is a focus group, which is done really early. That is usually pre-discovery. It can even be pre-suit. Or you want to do a mock trial, which is usually the tail end of discovery, or right after discovery, but before mediation, because what you want to do is get a value for your case. It's really a valuation tool. And when you get that value for your case, your best case scenario is you get exactly what you're looking for in terms of value, and you can take that and use it as leverage at mediation. And let's just say things go the other way, and it's exactly what you didn't think. You thought this was a $250,000 case, but mock jurors came back and said, you know what, this is a $7 million case. Then you have knowledge. You don't have leverage, but you have knowledge. You have knowledge to reevaluate, to re-reserve, to go up the authority chain, perhaps get more authority, and you have that knowledge going into mediation. So it really is an early assessment kind of tools that we use. So that's why I've always been team mediation. Post-COVID, there is no way to do virtual or in-person pandemic trials without selection bias. So I am absolutely team mediation now. Before it was maybe number 2 hit, now it's number 1 hit.
Okay, so you've said so many things that were absolute gold. Absolute gold, Shari. I mean, and you and I have had these conversations before, and anybody who's been paying attention knows that we've done several webinars on these issues.
This is how we met, through these issues.
Yes, it is. We met commiserating over how much we dislike virtual jury trials.
Absolutely.
Absolutely. But you're so right. I would love to see more attorneys use your services or litigation consultants early on in the process. I see attorneys showing up less prepared than they could be, and they have no idea that they're less prepared than they could be. You know, these are obviously well-meaning lawyers. These are good lawyers. But I definitely think that if they had, you know, a third party before they got to me, because, you know, I'm typically that third party they're looking to.
Sure.
But once you get to me, the
Correct.
insurance company has made a decision. They have a range where they're at, where they're going to settle the case on mediation day, right? And so if they had the opportunity to have someone like you to help them see some of the weaknesses in their case before I tell them about them, I think that they could be better prepared. So, and of course, not only weaknesses, but pros to the case. We're like, no, you've got this, and you're not playing it up the way that you should be. You could make this stronger, right? You could get more value out of this case if you focus on this. And then, of course, you know, the same thing if you're talking about the defense. You know, you could get a discount on this case if you talk about this, or you talk about it in this way. And that's how we go into the mediation. But I love that. I love the idea of moving the litigation consultant's retainer up. Let's move it up. Let's get you involved much earlier. And, you know, I always think it's better when people are looking toward mediation as their end goal, right? When they're looking at mediation as the end goal, as opposed to trial, because you can use your monetary resources differently. You can allocate them differently, and you can get where you're trying to be in a different way and quicker.
I absolutely agree. And one of my biases, and biases are something I talk about a lot, is I come from the defense world. I was a defense attorney on the civil side. Then I was at an insurance company for many years. And there are not, despite the fact that these are big companies, there are not unlimited resources. So if you are directed toward a really productive, fruitful, end result, cordial mediation. And there are so many advantages to a mediation, even pre-COVID, with respect to closure, with respect to reputation management. all sorts of things like that. And if that's your direction, you're going to really allocate those resources, which are not unlimited, to that end, rather than wasting your client's money just going full force, going to the mats in litigation. I mean, look, there are some cases, I am not saying every single case will and can and maybe should settle, but I really do think, and if COVID has showed us anything, it has showed us what a valuable tool mediation is.
Oh, absolutely. I really want to talk about um, your your stance or your opinions on the biases that are present when we're talking about, moving forward, going toward trial right now, because the juries look a lot different.
Absolutely. And there have actually been some preliminary research studies when I remember when the pandemic first hit and just kind of March, April, and everyone was just sort of figuring out what's what, and courts were closed, and we were learning about social distancing and PPE and just like all of these completely new concepts. And trials were tabled, and we didn't remember at first they told us, oh,
I
10 days,
remember.
we'll flatten the curve. We're gonna, we're gonna be okay. And everyone's like, oh, 10, maybe 14 days, we'll stay inside, we'll watch the Netflix. So anyway, I think then when we figured out, when the legal system figured out that this is going to be a little bit more long-term than those 2 weeks, that's when we started getting really savvy with technology and went to a lot of virtual proceedings, which is great. I think virtual mediation is great. And I'm sure you have just a ton of information about that and a lot of opinions about that. And you know what,
Oh, of
maybe
course.
there's deposition, deposition. I mean, there are things I remember I used to be running around from court to court, and there are certainly things that can be done more efficient virtually. Trials, I do not believe to be one of them. This was my first knee-jerk reaction, and I wrote an article, and it was really just raising a bunch of questions because we didn't know. This article was probably in April or May. And then after I started really doing the research and delving in and looking at some psych studies, and then there were some new studies done. And basically, so what we have with both in-person pandemic trials as well as virtual trials is we have a problem of selection bias. That I believe to be more pronounced in a virtual trial setting. In fact, I was just talking to an attorney. I've talked to a couple of attorneys who have done virtual trials, soup to nuts, starting with their jury selection. They were doing virtually all the way through their summations. And there is a problem with virtual trials because studies have shown virtual juries are going to be wealthier, they're going to be whiter, and they're going to be younger. And you are excluding parts of the population when you do that. What a lot of people don't know is with a regular jury trial, forget COVID, a regular jury trial a couple years ago, there's already selection bias because you're using voter registrations or you're using various ways where you are excluding people in the community, but that is so pronounced in a virtual trial. And I think I can also speak a little personally about that. I live in New York City. You know what, you may meet my kids. Everyone may meet my kids in a few minutes because we don't have a lot of room here in New York City. So if I don't have a lot of room, Winter, to do a podcast with you for, a half hour, an hour, think about me doing a trial in my apartment.
Right.
I would have to basically defer because of childcare. And that's another class of people who are going to be excluded from virtual trial. Caregivers who are disproportionately women. So you're going to have a trial or jury pool that skews very male as well. So really picture a bunch of white millennial males. Like I'm just picturing like 12 of my nephew, and I don't know if I'd want 12 of my nephew on the jury. I don't know about that, I have to tell you, no matter what side I'm on. So, so anyway, so virtual trials 100%. You have a lot of, okay, so urban environment like me, New York
Right.
City, where minorities have been disproportionately affected medically by COVID. You have a
Right.
serious selection bias there. You have people that are going to be deferring because of space issues. Whereas in rural communities, you may have people deferring because of Wi-Fi issues and connectivity issues. So you have that with virtual trial. In-person pandemic trials, let's talk about that. Serious selection bias with the elderly, serious selection bias. They are not showing up before a
Yeah.
vaccine. Serious selection bias with communities that have been disproportionately impacted by COVID. You have a
Yeah.
lot of problems. Again, my bias, I'm in an urban environment. You really have to take the subway or public transportation to get to most of the courthouses. There are people who will be able to afford a cab or an Uber. Selection bias. Once again, do you want your whole jury to be the ones taking Ubers? Maybe you do, maybe you don't, but that's a problem. That's selection bias. There's a ton of other problems with in-person pandemic trials, lots of challenges, logistical, theoretical, appealable, psychological, but that's my piece
And I love
for
it,
now.
Shari. I mean, I love it. You talk about um, bias and selection bias, but it's the same, and it's so important, right? And it's the same bias that we see in our everyday lives. This is not special for trials. It's not special to litigation. This is what is happening everywhere. Like it impacts absolutely everything that we do. And so I love talking to you about your knowledge in the area of bias, because it's so it, first of all, it's so scientifically based, and you are so knowledgeable about it. And it's not, when I hear you talk about it, it's never um I'll put it this way. When I talk about it, it's very personal. Obviously, as
Mhm.
a Black woman, it feels more personal. And I'm not saying it's not personal to you, but you do a really great job of talking about these biases in a way that does not feel personal. It's in a way that's very matter of fact. This is the bottom line. This is how it's going to affect your business. And it's like how you personally feel is of no consequence. It's not important right now. This is how it's going to affect your trial. Focus on that. Focus on how it's going to affect the bottom line. And I love that. And I tell you, having these conversations with you has helped me tremendously when I'm trying to have those same conversations with people in my mediation practice, because I've been able to take that language and use it and say, okay, you don't have to necessarily believe this in your personal life. Uh, Definitely not. However, this is what it looks like. This is what the research is showing. This is how other people feel, and this is how it's going to have an impact. You need to be aware of that no matter what, because whether you believe it or not, it's going to have an impact. And when you talk about it in those terms, or I talk about it in those terms, I can typically get attorneys to listen and say, all right, I don't necessarily believe this personally, but if this is something that is being seen, if this is what the research is showing, then I'm going to respond to it appropriately. And I have a hard time believing that attorneys who can recognize that in the mediation space don't take that to heart and take it home. You know what I mean? I think it really gets to them. And it's one of those things where, I mean, I'm a mediator. I could make a case for mediation any day of the week, but I genuinely believe that mediation makes people's lives better. I think that everything that you learn while you're in mediation, and the techniques and the information that I give during the mediation, I think people take that home with them, and I think that it affects how they view the world. Do you have any opinion on that?
I think that's a really interesting point. And of course, it's not something I really ever thought about with respect to mediation, but I do think about it with respect to the work I do and how it's transferable to my life. And there was actually a really interesting post on LinkedIn today. I'm on LinkedIn quite a bit, Winter. How about you?
Yes, just a bit.
So just a bit, just a bit. I see you're networked in the back. I have my networked in the back. So anyway, we're on LinkedIn quite a bit. There was an interesting post today about labeling feelings. And like sometimes when you are feeling a certain way, it helps to really label the feeling. And I responded because something I do with jury research a lot, and something that's very relevant and talked about a lot by the defense industry, are nuclear verdicts and about arousing anger from your jurors. And so I've researched and looked at anger and fear a lot. And I think, and I've concluded a lot of times anger can be a mask for fear. So that's something I've taken from my work and applied to my life. When I'm angry about something, I mean, maybe I was angry about something this morning, and was that really anger, or was the underlying emotion fear? So, to your point, things that you've learned in mediation, and mediation is really just such a wonderful, it's a wonderful skill for life, because how are we not mediating? I mean, you have 4 kids, like you're probably mediating like every like 5 seconds in
Every
your
second
life,
of every
like
day, right?
everything. It's all compromise. I mean, here we're in my apartment. We have like 4 Zooms going on. Okay, who is this room? Who is this room? What time is this? Like, life is a negotiation. It is a compromise. We don't live in a vacuum. So I could see how all of our lives, whether we're in medicine, whether we're in law, whatever we do, we learn and we apply in our lives. But mediation is probably one of those really excellent niches where you're applying some really great skills to your personal life, and you're improving your personal life through those skills.
Yeah, I definitely think so, and I'm gonna ask you to start paying attention to that when you're prepping people, um, with your mock trials and your litigation prep, and see if people start to change their minds or their opinions, like, legitimately, because obviously you spend more time with people than I do. I'm spending maybe a day, 2, 3 with people, no more than that, and they don't call me and tell me that I've changed their lives, but
Right.
you might get a better read on that than I do. So I would love to know that. But I think that, another really cool thing that you and I have talked about, because you have so much experience with psychology and, like, really studying psychology. And part of my preface when I'm mediating, I tell people, like, this really is your day to get all of those emotions out. I'm here to listen to you. I'm here to let you vent. I'm here, whatever you need to do. Today is your day of catharsis, right? But of course, I'm not a psychologist. I have zero training in
You
psychology.
have FOMO. You have FOMO.
Yes, I do. I totally have FOMO, and if I had more time, I would tell my husband that I needed to, like, get, like, a degree in it. He would have a fit, but I would probably say it and suggest it. But mediation to me is really about closure. It's about giving that plaintiff closure, right? It's, sometimes, depending on how it is, what kind of defendant you have, sometimes it's about the defendant getting closure as well. But typically the stuff that I do is not. It's really about the plaintiff getting that closure and being able to move on. And so that psychological angle is super, super helpful to me. And I'm wondering, when we talk about closure, do you think the same way that I do? Do you think that mediation is a good way for plaintiffs to get closure?
I think it's, and here's my bias, I think it's actually a good way for defendants to get closure as
Okay.
well. And that's because I come from the defense side of things. So, yes, it is a very, first of all, it is a very amicable, it is a very, especially if you know you're working towards that, like we were saying, you really approach things and use resources differently.
Mhm.
However, the closure, I mean, you hear about plaintiffs who are, I mean, hitting the jackpot, like these talc cases, $4 billion, these pesticide cases, hundreds of millions of dollars. Well, you know what? Those are going to be appealed forever. And probably what's going to happen is there's going to be a post trial settlement, some type of post trial mediation. So, really, you always want closure, and a verdict is not closure. So yes, plaintiffs, they can go on with their lives. I'm just kind of, again, my bias thinking personal injury plaintiffs, but really any plaintiffs can go on with their lives. But for defendants, a lot of times there's a lot of reputational, there could be reputational damage at stake. I'm
Right.
thinking of big pharma. I'm thinking of some of these companies that have taken huge hits over the last, the pre-COVID years, and then having to do PR spins, and their shareholders and their stock prices are plummeting. So there is really like a nice privacy. There is a nice closure. There is a nice reputation management aspect to mediation, that I think is great for defendants. There is also, if they're trying to budget for something, it's a little bit more transparent about how they're going to budget for a settlement, rather than trial costs and experts and something that just gets totally out of hand. You don't know, you can't budget for trial as well. And so I think those are important considerations as well. And then there was something else that came up. It came up in a case I was working on, and it kind of made me realize why mediation was even that much better. Is so I talk a lot about humanizing the corporate defendant, and I was looking at something
Yes.
and kind of figuring out, okay, how are we going to do this? Well, you want your corporate defendant, whether it's a CEO of like some huge company, or whether it's like a mom and pop, like small company, you want that CEO or that president in the courtroom. You need the face of the corporate defendant. Well, you know what? There's an issue. If this is the CEO of a huge pharma company, are they going to really be able to sit there for 3 weeks? Like, you're taking a lot of their time. You're taking a lot of, I mean, there are major
Right.
things
It's
that could be
expensive.
going on in this company. So that's a consideration too, when you say, you know what, go to mediation, go to settlement. It is a day, 2 days, maybe it is a series of phone calls back and forth, or virtual, or whatever it is. It is not the uncertainty of I'm sitting for weeks during a voir dire, I'm sitting for weeks at a trial. But that's still, if you commit to that, if you're a company and you commit to that, you need to be there. Like, we need to be able to humanize you. We can't humanize an empty chair. So that's just something that came to mind, and also really weighs in the favor of mediation.
I love that. I love the idea of reputation management. I think that that's really, really important. I think that's becoming more important every day, especially during the pandemic, with people suffering as much as they are. We're seeing people losing their homes, and of course, when things like this happen, when we have recessions and economic strife on this level, we do see an increase in lawsuits. And so, of course, we start to see the same large companies being sued over and over and over again. And they start to get a reputation for how they handle those things. And I think that you're completely right. If you want to manage your reputation, the best way to do that is through mediation, because mediation is confidential. You're not dragging your business through the streets, the proverbial streets, right? you know Trials are open. They have to be
Absolutely.
open. They absolutely have to be open. And right now, with the pandemic, for the most part, the way that a lot of courtrooms and jurisdictions are handling that is by putting trials on YouTube. Do
Mhm.
you do you want your CEO on YouTube
No.
for for everyone in the world to be able to log in and see? I mean, I think that's terrible. I've been on both sides of the V, right, as the litigating attorney, um, and the thought of that is horrifying, because no matter how well you prepare someone, trial is just different. It's nerve-wracking. um it People are just extra nervous when you're talking about trial. And then I would also imagine that the thought of being broadcast on YouTube for the entire world to see makes makes that even worse.
There's a lot of pressure. I think there is a lot of pressure, whether you're testifying on behalf of the company or whether you are just sitting there at the counsel table. There is an extraordinary amount of pressure. And yeah, that is one of the pitfalls of trial for sure. It's a downside.
Right. And with mediation, of course, we have the benefit of confidentiality, like I said. And the things that you learn at mediation, if you don't settle, they can't be used against you at trial. And other real listen, I'm always going to make a case for mediation. You can learn so much. You learn so much about the case and the other side's case, and what's going on, and how do we best work this out? How can we work together to make this a positive experience for everyone, on each side, right? And
I
you don't.
agree.
Yeah, yeah. And you don't see that at all, because once you've gotten to the trial stage, people are dug in, they're angry, they have spent a ton of money, and they need to make a lot of money on the judgment,
Mhm.
if you're a plaintiff, in order to make it worthwhile. And so, of course, the farther into it you get, the less likely you are to settle for a lower amount, obviously, because you put more money in. And then the same thing, it's true for defendants. Once they have put that much money into their defense attorney, if they're, and I'm kind of operating off of the thought of the defendant being insured, which is of course not always
Sure.
the case. But once you're that far into it, even for an insurance company, it's like I'm just gonna roll the dice here. Like,
Right.
why not? We've gotten this far. We haven't been able to agree. Let's just keep going. Let's see what happens. Because, once you get to trial, the defendant could just win. And you could get
Absolutely.
you could get a defense verdict.
I
Um,
mean, go ahead.
no, go ahead, go
Oh,
ahead.
I was going to say that's actually another cognitive bias. Like once you're in so far, it's really harder to, and I've talked about this on a podcast, kind of like you're reading a book and it's not that great, but you know what? You're like 75 pages into the book. You kind of feel obligated to finish it. Same with the movie. It's just that kind of like
Mhm.
almost like a sunk cost fallacy, cognitive bias. So yeah, absolutely. Like your trial attorneys have started, they've given their openings, witnesses have testified. It's a lot harder to extricate yourself from that situation. And another thing that I was thinking about just lately, another pro really for mediation is, again, back to reputation management and back to kind of like that nice privacy about it. You know what? These days with the internet, you Google someone's name and you see if they are involved in lawsuits. Like you will see like some horrid history come up, whatever it may be. I mean, it could have been like a business deal. I mean, it could have been they were sued for like no good reason, or maybe just
Right.
sued someone, whatever it is, it comes up. Mediation, you're totally getting around. Again, it all kind of goes to reputation management, but I think that's pretty significant.
You know what? And I'm glad you mentioned that, because it really brings up the case for pre-suit mediation, right? And
Yes.
maybe bringing you in pre-suit, like right away.
Yes.
If it looks like it's going to be a bear, bring Shari in early, and start really getting your arms around like what this case might actually look like. Because as you've been so eloquently saying, we all have our biases. And if you're not trained to see them, you're not going to see them. And even if you are trained to see them, it's hard to evaluate those things when you are in the middle of it. And even when you're the attorney, it starts to, those things start to take on a very personal feel a lot of the time, and you become very personally involved, and you can start to take on the needs and the emotions of your client. And so you can start to lose sight of, okay, well, yes, this is what I'm hearing, this is how I'm feeling, but this is a bias, and so I need to eliminate that from my thought process. I need to work on this when I'm talking about the evaluation. It's hard to do that, and it's hard to do that no matter who you are. And
I
so,
think, oh, go ahead.
no, honey, go ahead.
Okay, so I was going to say, Winter Wheeler, I think you have secretly gone to grad school for psychology and just didn't tell me, because you have just described one of the most detrimental biases to the litigation process, confirmation bias, also
Okay.
known as falling in love with your case, falling
Hmm.
in love with your defenses. I like to tell my defense attorneys. So 100%. And it's really, I tell advocates, it is normal. It is actually, it is almost good to have, look, you're arguing motions, you're reviewing documents, you are writing briefs, you are defending depositions or taking depositions. You are committed to being that zealous advocate. When you go, I remember I used to go argue insurance coverage motions on behalf of insurance companies. And you know what? It was not the most interesting thing, but when I walked into court, I was going to be the best, most passionate advocate for my insurance company clients. And I was going to advocate to death because that was my job. However, you have to take off that advocacy hat when you're actually taking an objective look at your case, whether it's a dangerous document, whether it's a settlement evaluation or demand, whether it is your defenses. And you have to take off that advocate's hat and put on that neutrality hat and really review that like in neutral, objective terms. And I think sometimes people will rely, I'm sure you see it, they will rely on the media to be taking on that role. But if they do it before mediation, whether it's a focus group, whether it's a juror perception study, whatever it is, they can really get an objective view of the facts of their case, the strengths of their case, the weaknesses of their case, and make your job that much more productive and, frankly, have a better chance of reaching settlement.
Oh my goodness. Yes.
That's a
All of
lot.
it.
That's a
All of
lot. Yeah.
it. It was a lot, but you're spot on. You know, because when you start that process in advance, you can get much farther, and more quickly. And yes, a lot of people do. They rely on me, or the mediator, whoever your mediator is, to be that third party, to be that voice of reason, and I'm happy to do it. Happy to. I love it. That's my job. But I definitely believe that if they started that process earlier, and of course, a litigation consultant is a great way to go. I think you could also do that potentially with a mediator, if you involved a mediator earlier. I don't know, maybe, who knows? Um, that's just the mediator in me.
No, I mean, look, I'm a huge fan of pre-suit anything. I've done consulting pre-suit for cases. The cases were actually very super private, super confidential. Both plaintiffs and defendants wanted to really maintain the privacy, especially if plaintiffs were minors, and there was no one wanted anything to be public. So these were cases, not cases, these were pre-suit claims that we looked at and eventually got mediated pre-suit. So I'm on the same page with you there. Absolutely.
Yeah. And I mean, I don't think that you can go wrong by involving that third party, whether it would be someone like me or someone like you earlier, or both.
Both
Right?
of us. We
Yeah.
have fun, right?
Oh, I mean,
We make it great.
the best thing anyone
I
could
know.
do is
Ever.
call both of us.
Right. I mean, we wrote a book together, right?
We sure did, right? Here's our book.
Absolutely.
Our book is amazing. If you haven't read it, #networked. Amazon
Network.
bestseller.
This was, yeah, absolutely.
But it's certainly, and then I think that another really important thing to talk about is that you can save money. And it always comes across when we have these conversations that we're talking about people spending more money, but in reality, you're saving money. You're spending your money on a different thing and at a different time. You're spending more money up front, I suppose. Sometimes, and I think if you know what, let me not say it that way, because you're not necessarily spending your money up front. I think what we're advocating for is for people to spend their money up front and not necessarily wait until the end to bring us in, right?
Right. I think you can look at it as you're making an investment. It's not an expense, it's really an investment. Also, you're getting that certainty. Like, I am going to tell you, this is how much my focus group service is. Just like you're going to say, this is how much my mediation is. No one is going to be able to predict, okay, for trial, we need this expert, that expert, the other expert. Voir dire is going to take this many days. We'll be billing this many hours, whatever it is. So not only do you have certainty with how much you are investing in your case, but as someone I knew at an insurance company liked to say, what you do not spend in defense, you're going to spend in indemnity and reputation damage. So I think that's an important takeaway.
Yes. Oh, I love the way that you said that. And I think back to my defense attorney days, and when I would write up these and now looking back, it just sounds so crazy. But when I would write up my budgets, my trial budgets, and I'm like, well, this could cost us anything from $30,000 to $60,000,
Right.
depending on whether we did A, B, and C, or we did that, or we did that. And then if they do this, then we have to do that. But if they don't do this, then we don't have to do that. But
Too many permutations, like too much of like a flow chart analysis where it's just kind of like, okay, this many hours of mediation, this is what you're going to pay. Mock trial, this is what you're going to pay. You have certainty, you're investing in your case, what you're paying in defense. Of course, my bias, I'm talking to defense attorneys. You are not going to be paying an indemnity. So those are kind of my top three.
I love it. So Shari, please, 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 I want to hear more about you and your business and what you've been doing since the pandemic.
Pandemic, a horrible, terrible thing. So many people sick, and living in New York City, I really had ambulances every night. There was a morgue across from my apartment. I am not downplaying COVID-19 whatsoever. It is really it kills me what's happened to my city. But me personally, I used it as an opportunity to start a business, to build a business, I met an amazing network of women on LinkedIn, including you, just through really interesting conversations and just great. I mean, we met through the virtual trial post, like just having a lot of common shared interest and really wanting to find a group of people who were passionate about helping each other find opportunities and just kind of throwing opportunities each other's way. And I found this incredible sisterhood, you included. We wrote this phenomenal book, Networked. Here come my kids. They're going to hear me talk about Network more.
I can hear mine too.
They're used to it. Maybe you'll meet them. But anyway, started this really like just wonderful process. And so now I'm doing litigation consulting. I started a course. It's called Encyclawpedia, where I teach the psychology methodology for litigation education, and having a great time preparing for the course. It's just all of the stuff I love. I love teaching litigators how to use psychology to help achieve favorable, litigation outcomes. And so that's what I'm doing, that like hanging with my sisterhood and really just waiting for this vaccine, wearing my mask, and I can't wait to meet everyone in person. So that sums it up.
Oh my gosh, Shari, I'm listen, I love you. I am like completely obsessed with you. and have been for months now, I guess.
Mutual Admiration Society here.
Yes, Mutual Admiration Society. And I want to thank you so much for being here. You are my first guest. I love it.
So honored, and I'm so honored. Let me just say a quick word about my friend, my co-author, my inspiration. Winter Wheeler is just, people say the 5 people who you spend the most time with, that really shapes your personality. And she's one of the 5 people I spend the most time with. And she's just pushed me to just new levels and inspired me and worked so hard. And I wish you all the success in the world. I think you're amazing. I'm so thrilled to be in your circle, and you so graciously invited me as I interjected myself in your post and you started posting my articles, and I just love you to death. So I'm thrilled to be here. And I know you'll bleep out where I was like, what, before at the beginning.
I may or may not, I don't know.
All right, whatever. This was fun. This was fun.
Really
Congratulations.
Fun. Thank you so much. Thank you
Congratulations.
So much. I really appreciate it. Thank you. And congratulations to you on your new business and to Encyclawpedia. I think everyone needs to check that out. I'm super excited. If you are not following Shari on LinkedIn, you need to do that. She is Shari Belitz. She's easy to find. She's the only Shari Belitz on LinkedIn that I know of. I mean, I've looked.
I think so. And www.sharibelitz.com is my website if you want to nerd out on a couple good articles. And I have a couple pictures of Winter and myself doing some other seminars and things like that. So
do you? I need to go.
Yeah, I do. We did the Fringe. We have the virtual trial webinar. So go check it out. Go see yourself on my website. And
check it out.
Yeah, so this was fabulous.
Oh, thank you so much.